Good morning, ladies and gentlemen. Welcome to County Court at Law Number 6 and the Bexar County Veterans Treatment Court Zoom hearing set today, which would be Friday, the 30th of April 2021. Today we are looking at motions to dismiss for lack of speedy trial on various cases. For the record, we had previously set cause number 636-836, State of Texas versus Gregory Corbin Marquardt, represented by Luis Martinez for this hearing. Mr. Martinez is currently in a conflicting felony court hearing at this time and will contact Ms. Benavides and reset this case for next week on either Wednesday or Thursday at 2 o'clock. We previously had set today cause 655-473, State of Texas versus Perla Acosta, represented by Miss Veronica Legarreta. Ms. Legarreta contacted me and told me that in her opinion, the facts of her case did not support this motion at this time and didn't want to waste the court's and the state's time. So just hold it in abeyance and see if at some future point it becomes relevant. So we will just leave that in the file unless she wants to reset it at some future point, which leaves us with two cases. Cause number 389-841, State of Texas versus Blanca Aleman, represented by Miss Julie Pollock, and cause 638-436, State of Texas versus Benjamin Gomez Diaz, represented by Mr. Robert Jimenez, both of which are motion to set aside information for failure to afford constitutional right to speedy trial and defense motion to dismiss for lack of speedy trial, basically the same premise. So let's start with Ms. Pollock's case, cause 389-841, State of Texas versus Blanca Aleman. Ms. Pollock, are you ready to proceed at this time?
We're ready, Judge.
Your Honor, I don't know whether Ms. Aleman, though, is up with the interpreter so she can understand what's going on.
Ms. Aleman, can you hear me at this time? And of course, I'm speaking English. Is Ms. Abrams our interpreter?
Yes.
Ms. Abrams, are you in contact with Ms. Aleman at this time? I don't see how we can proceed, Julie, unless we are able to fully communicate. Do you have any insight into what we might do?
Well, could we reset this for next week and maybe get her into the courtroom?
Well, courtroom's not going to work because we're not doing any in-person proceedings until the plague is over. She can come to your office and y'all can sit there perhaps and utilize your one Zoom capability with your computer. That might work. Ms. Abrams, is there any other way we can do this that you're aware of that we could resolve it this morning?
I can have her into my office. We can use my computer. Hopefully that works.
Let's do this next week on Wednesday and Thursday. And Pat, correct me if I'm wrong. We have hearings set primarily for pleas and motions to revoke probation at 2 p.m.
Yes.
on Wednesday the 5th and Thursday the 6th. And y'all can pick either one of those and we'll just add you on to that. And hopefully we can resolve the translation problem by then. Would that work for you, Ms. Pollock?
All right. I'm sorry. What day?
Wednesday the 5th at 2 or Thursday the 6th at 2.
And we're in May, right?
Yes.
So May 6th at 2 would be great.
All righty. And we'll set you for Thursday.
Before we go into this hearing, which may take a while, the one issue that came to mind when I was looking at all the facts of your case on Ms. Aleman is the fact that she apparently became a fugitive on or about April 13th, 2012, and was not rearrested until, hang on a second, please.
Your Honor, I don't believe she was a fugitive. She was arrested on that date on an at-large warrant.
Here's what I'm trying to point out to you. So let me finish and then you can certainly jump in and state, correct me if I'm wrong. My records reflect, from looking at the page on the computer that Ms. Benavides sent me, obviously I have no personal knowledge of any of this. The records reflect that the original offense date for Ms. Aleman was July 10th, 2011. That she became a fugitive, i.e. she was originally arrested on 7/10/11. She made bond.
No,
She was assigned. I'm sorry, what?
she was not arrested on that date.
All right.
This is an at-large case.
Ms. Pollock, if you don't let me finish, I'm not going to be able to communicate with you. Please don't interrupt me again. Let me.
All right. Sorry, Judge.
You try again. Ms. Aliman, my records reflect that on July 10th, 2011, Ms. Aliman, that was the date of the offense. Apparently, according to my records, she was arrested and given an arraignment setting date of April 13th, 2012. She did not show up for her arraignment date, is what my records reflect. I don't know what actually happened. That was the same date this case was assigned to County Court 6. She was ultimately arrested on 9/11/20, at which point the series of events occurred that brought us here today. And your motion to set aside information for failure to afford constitutional right to speedy trial was filed on March the 10th. State, what do your records reflect? Is my recitation correct, or am I incorrect somewhere in there from your perspective?
Judge, from my records, it is correct that the offense date was 7/10/2011, and that for purposes of the Barker factors in a speedy trial, that it doesn't run until this case was filed at large, which the case was filed at large 4/13/2012. At that point, when the case was filed at large, a warrant was issued, and she became a fugitive up until she was arrested on the warrant in 2020.
So I am incorrect, and she was not arrested originally and given an arraignment date. Is that correct?
Correct, Judge. Correct.
All right, Ms. Pollock, you're right. Would you like to say anything other than I apologize that I was incorrect?
Well, I apologize for interrupting you,
No problem.
but I believe those facts are correct as recited by Mr. Maru.
All right.
She
Well,
was not arrested on the day of the offense.
thank you. Why don't you look at your schedule and talk to your client? And this is not a life and death has to be done today or even next week. Find a time in your calendar that you can coordinate with Ms. Benavides that y'all are available. I don't think this will take probably 30 minutes, if that, but that, who knows? You're welcome to use as much time as you wish when you want to actually hear this. But our next two openings for next week are going to be Wednesday, the 5th of May and Thursday, the 6th of May at 2 p.m. in the afternoon. So if those work for both of you and we can get the interpreter available and our communication efforts hopefully will work better, let's do it then, or any other time that's convenient for you guys. Our normal times are going to be Mondays at 2 p.m. and Thursdays at 2 p.m. other than next week because we have VTC issues.
All right. The 6th at 2 p.m. works fine for me.
All right, Pat, okay?
Yes, Your Honor.
And Ms. Abrams or another interpreter that day?
Yeah, I will ask for another interpreter at time.
All right. And Julie, will you relay that to Ms. Aliman?
Yes, Your Honor. And
Thanks
just for the record, I had filed my motion. You have a copy of that, correct?
I do, absolutely.
And I filed a trial brief on that same day, March 10th. Do you have a copy of that?
And I have that also. And that I feel that to be filed March 11th, 2021. Or, I'm sorry, filed on March the 10th, actually received by the court March 11th, 2021.
Yes, Judge.
Okay.
Okay.
Thanks for your
All
help.
right. We'll see you on Thursday.
Thank you.
Thank you, Ms. Pollard.
Thank you.
Okay, next case. Now, are we having communication issues with Mr. Benjamin Gomez Diaz also? Okay with that. All right. This is cause number 638436, State of Texas versus Benjamin Gomez Diaz. This is a defendant's motion to dismiss for lack of speedy trial. And Mr. Gomez Diaz is represented by Mr. Robert Jimenez. Are you ready to proceed at this time, Mr. Jimenez?
I'm ready, Your Honor.
Okay, Mr. Gomez Diaz, the first issue I need to resolve is I'm looking at a document entitled Defendant's Consent to Hearing by Video Conference, which purports to have both your signature and your attorney's signature on it. Mr. Gomez Diaz, is this your signature on the Defendant's Consent to Hearing by Video Conference document?
He's muted, Your Honor. He needs to unmute.
Is that yes?
Sí, es mi firma.
Thank you. And Mr. Jimenez, an attorney for Mr. Gomez Diaz, is this also your signature on this document, sir?
It is, Your Honor.
Thank you. Okay, at this time, Mr. Jimenez, would you go ahead and outline for the state and the court the basis for your motion to dismiss for lack of speedy trial? Let me quickly just insert what information I have, and you can either say that's correct or not correct. I show your motion was filed on April 1st, 2021, received by our court on April 5th, 2021. And the D page or whatever on this gentleman's record on the computer that I had access to shows the offense date being October 4th, 2019, that the state filed the actual information on this case April 30th, 2020. It was assigned to County Court 6 on May 1st, 2020. And your motion or to dismiss for lack of speedy trial was filed on or about April 1st, 21. You agree that those are the key dates on this case, Mr.
They are,
Hunt?
Judge.
And state, do you agree those are the key dates on this case?
Judge, this case was also filed at large, so the tolling would not begin until the case was filed at large.
Okay. Well, would that be the date the information was filed?
Yes, Judge, and the date that the warrant would have been issued.
I have April 30th, 2020. Would that be the date that all time starts in this case from the state perspective?
Correct, Judge.
I think the Wingo, Barker versus Wingo factors say the date of the offense is actually the date the time starts.
The judge
Or
in
the,
Judge, if I may, in Barker, they lay out that if the case is filed at large, you start counting from the time the day the charging document was filed.
okay. Defense, do you agree with that?
I agree with that that holding. However, I do not agree that that is the date that Mr. Gomez Diaz's time starts to run.
When do you think Mr. Gomez Diaz's time should start to run?
I believe it runs from his offense date, and the reason being, so in Barker v. Wingo, it states that the time runs either from the date of arrest or the date that a formal accusation is brought. So while the formal accusation was brought on the 30th, Mr. Gomez Diaz was actually, in our opinion, arrested on October 4th. He was arrested by SAPD on October 4th. He was taken to the magistrate's office. He was given a breathalyzer test, but for some reason that's not quite explained in the documents, they released him without having him be magistrated. He was, in our opinion, arrested. He was handcuffed, taken from the scene of the initial arrest down to the MAG's office, given a breathalyzer test, and then from either the MAG's office or I don't know if they took him to the hospital or what, they released him without taking him back to the magistrate's office. So our opinion is he was in fact arrested on October 4th.
And what offense was
Yes, ma'am.
It's a DWI, Judge.
defense with regard to the day that Mr. Gomez Diaz is part of the offense and was, in your opinion, technically arrested? I think you're probably exactly correct. On 10/4/19, did he spend the night in jail or have to spend the night in the hospital?
Okay.
Or what exactly happened?
From what I understand, Judge, is he spent the night neither at the jail nor at the hospital, but SAPD simply released him. They told someone to come and pick him up. I believe they picked him up from the magistrate's office.
Okay.
But he did not spend the night in either place.
State, do you agree with that?
No, Judge, if I may clarify, the offense report clearly states that he was 52X, which means he was released because of hospital. What had happened was, without getting too much in the facts of this case, there was a rollover accident. He was detained in the state's opinion and taken back. And then at some point they determined that he was injured and he would need to be cleared by medical. So from what the state sees is generally in DWI cases, when there's an accident, they end up being filed at large because the person goes to jail and is booked, they're released to go to their own recognizance. And that's why the case has been filed at large.
Okay. Well, I think ultimately what we're going to find out is that if he wasn't actually in jail, that doesn't really count against the state anyway. I mean, obviously the time frame is involved, but if the defendant didn't suffer any harm at that point in time, and I'll let the defense. Let's go ahead and Correct me if I'm wrong. We need to have Mr. Gomez Diaz's microphone turned on, and now it's turned off, and we don't get the jail noises. That
No,
work good?
he turned it off. Do you want it on?
Okay. See, you still hear the interpreter, correct? All right, great. And he turns his microphone back on again if he needs to talk to the interpreter. All right, great. All right, I apologize for minutes. Go ahead and advise the state and the court your basis for your motion.
Yes, Judge. So again, our position is that the time frame begins to run from October 4th, 2019. However, in the alternative, even if the time frame doesn't run until April 30th, 2020, that would still be a time frame of 9 months, which would be sufficient to trigger a review under the Barker v. Wingo factors. I believe 8 months has been held to be presumptively enough to trigger a review. So regardless of which date you use, it's still sufficient to trigger the first prong of Barker and have this case up for review. Once that's done, the burden shifts to the state to show the reason for the delay. As this court's well aware, different factors are accorded different weight. Negligence is afforded a lower weight than intentional delay, but still would fall on the wrong side of the divide for purposes of a speedy trial hearing. It's our position that there is no basis for the delay. The warrant was issued April 30th, 2020, and I am not aware of any due diligence that the state exercised in trying to have Mr. Gomez Diaz arrested, brought to court to defend himself against the charges until he was arrested in January of 2021. The next factor that the court would proceed to then would be his assertion of the right. Now, obviously, in Mr. Gomez Diaz's case, he was denied an opportunity to assert the right until January of 2021 because he was not made aware that there was a case pending against him. He was never brought to court. So that alone doesn't cut against him, since it was not his responsibility under the case law to bring himself to court and defend himself against the charges. Now, once he was arrested in January of 2021, he was given several settings at jail court. He refused all offers that were made, and he requested that this case be sent back to the trial court so that this motion can be heard. Now, we were not his original attorneys in January. He had been given an appointed attorney. So he did come in a little bit later, I believe sometime in February, I believe is when we entered the case. But at all times, regardless, Mr. Gomez Diaz did not accept any offers from the state and simply requested that his case be brought back to the pending court, to the presiding court, so that he could defend himself against the charges. And that's a factor that we believe weighs in his favor regarding the speedy trial analysis. Regarding the final factor, which is prejudice to the defendant, we would assert, it's asserted in our motion, that had things been done in a timely fashion. So number one, despite what we consider his arrest in October, they had all of Mr. Gomez Diaz's information. They had his address, his identifying information. He could have been arrested soon thereafter. Had that been done, we would have been able to photograph the scene, take pictures of the accident scene, inquire with an expert if needed to, because certainly the state would use the evidence of an accident to bolster their argument that the defendant was driving while intoxicated. So that is certainly a factor that would weigh heavily against him. Losing the opportunity to investigate that and prepare a defense to counter that assertion has certainly prejudiced Mr. Gomez Diaz's case. Even if the court were unpersuaded by that, the case law has held that just because there is no specific damage to a case, that does not free the state from its obligation to bring people to court in a timely fashion, even without any actual explicit prejudice or specific prejudice. That does not cure the delay by the state and make it okay.
How many days in jail did Mr. Gomez Diaz actually spend when I guess that would start when he was actually physically arrested and put in jail back on 1/24/21? Does that sound right?
That sounds right, Judge. He's been in custody ever since.
Okay. Based on, exclusively on this case, or are there other factors involved that are keeping him in jail other than this case?
He does have an immigration detainer, Judge. So we have not bonded him out because then ICE would pick him up and we'd lose the ability possibly to defend his case here.
At what point did he start having an immigration hold? Before this case happened, or some point during the time, or what date specifically did the feds put a warrant out for him?
I believe that his immigration hold was only put up after his arrest in January. That's usually the way that it works. A person is arrested and then the jail makes contact with ICE, or ICE here in San Antonio will sometimes do weekly sweeps to check and see if there are any non-citizens in, and then they execute a detainer.
Okay, so it's not your position that the state is responsible for him being jailed this entire time on this case because he has an immigration hold also. Would that be accurate?
Somewhat, Judge. I mean, our position is had the case been filed back in 2019, he would have actually, I believe, had a better chance at making bond. The immigration detention situations were a little bit different, and he would have, in our opinion, had a slightly better. I'm sorry, Judge. He would have had a better opportunity to either make bail or resolve his case in the interim time since the offense date and today's date. Immigration has taken a much harder standpoint on DWIs. So there was even the possibility that had he been brought to court promptly in 2019, that he actually could have maybe resolved this case, either through a jail court offer or simply pleading to, a probation offer. But as it stands now, because of the way that immigration treats DWIs, it could in a very negative way harm his ability to obtain any immigration benefits.
Okay, but still what you're telling me is, regardless of this case, once he was brought to the attention of the federal authorities, ICE would have put an ICE hold on him from the date he was arrested, 1/24/21, to the present. Would that be accurate?
I believe that's accurate, Judge, yes.
Okay. And would you agree with me that if the offense date was 10/4/19 and the state filed information on 4/30/20, that was within statute of limitations?
It would have been within the statute of limitations, Judge, yes.
Okay. Anything further? I'm going to let the state talk.
Nothing at this time, Judge.
You can come back and answer anything they want to say when we're finished. State, Mr. Maru, go ahead.
Judge, so to begin with the length of delay, I agree with defense counsel that it was 9 months. However, Barker has stated that the limit is 8 months. So that's when it is presumptively and it triggers the rest of the elements. So I do agree with that. However, the defense's argument is a little counterintuitive. To begin with, they wanted to say that the defendant was arrested, but then proceed to go on and say, well, how could he have known he had a case against him because he didn't know anything? Well, if he was arrested, then he would know that he had a case against him. If he was taken to the jail and as they claim he was arrested, there would have been a case. Putting that aside, it looks like from the time that the case was filed at large on 4/30/2020 until the warrant was executed successfully executed on 1/24/2021, that there was a 9-month period where Mr. Gomez Diaz would have been a fugitive in that time. It's the state's position that these types of numbers, while they are relevant, should not be considered as a cause of delay against the state, that this should be against the defendant contributing to these factors. Looking at it, Judge, at the end of the day, going with this logic, defense counsel would just be telling their defendants, hey, go on the lam as long as you can, because eventually the state's going to have to dismiss this case. I mean, that's the logic we're following at this point. There's a reason why there are statute of limitations in place for 2 years to give the state the time to file a case, to do their due diligence, to see if it should even be brought in front of a court. Furthermore, as Mr. Jimenez stated, this case was brought to jail court multiple times where the defendant was given an offer. And as far as I'm concerned, through the changing of attorneys, which also contributes to the delay that they claim has been going on, what happens is we made the offer. Not once was there a trial ever requested. If they would have requested a trial, we would have said state's ready. Let's set it for a trial, but not once was it requested. They were made offers, they denied the offers, and then they filed a motion for lack of speedy trial. So it's the state's opinion that had there been a jury trial setting or something like that, we wouldn't have said not ready. We would have been ready. We have everything that we need to go forward. So that goes towards the assertion of right, that he never asserted a right for a trial up until this motion was filed. And the prejudice, going to prejudice, the state feels that there's been no prejudice. According to defense, depending on which argument you want to go with that they presented, he didn't have any prejudice or emotional distress because they claim he didn't even know that this was going on. So how could he have been emotionally impaired by this? Additionally, going towards the crash scene with the experts and everything, while that could have been done, there is still time to go do that. I mean, we see cases where, we prepare for trial that are much older than this, where everyone is still able to get the evidence and the witnesses that they need to successfully put on a defense or pursue prosecution. So it's the state's position that, especially during a global pandemic, where the Supreme Court of Texas has come down and said, tolling periods and things of such nature need to be pulled off, because if we go to the due diligence argument, which really only applies to motions to revoke, condition number 5, but if we were to apply it here, I don't think the Supreme Court had in mind, when they were telling us all to work from home, when everything else has been put on hold, dockets have been stacking, that they would want people to be executing misdemeanor warrants at people's homes in the middle of a global pandemic. So as a result, the state feels that while this is Mr. Benjamin Gomez-Diaz is partly at fault here for being a fugitive for 9 months, that also the pandemic can be to blame for the execution of warrants and things of that nature.
Anything further, Mr. Jimenez?
Yes, Judge, just a brief response to the state's point. So we obviously take the position that, and case law supports it, the defendant does not have the obligation to bring himself to trial. That is the purview of the state. It is their obligation to bring a defendant to court for trial. So the fact that Mr. Gomez-Diaz was arrested or detained in October, then released without any information whatsoever as to what was going on with his case, he has no obligation to start making phone calls about, well, do I have a case against me? Have I been arrested? Is there any information against me? That is not his obligation. That is solely the state's obligation. And further to the state's point that, well, defense counsel would simply tell their clients to run. I mean, number one, Judge, I think we have an ethical obligation not to do that. I think it would be unethical of any defense counsel to tell their clients to become fugitives and run from from their obligations in court. But secondly, that's not what happened in this case. In this case, Mr. Gomez-Diaz became a fugitive through no fault of his own. He did not run from his obligations in court. He was just simply never notified. And again, that's the state's obligation. As far as his assertion of the right, Judge, part of the bringing of a motion for speedy trial is that once those Barker v. Wingo factors have been triggered, it's too late for the state to say, okay, well, now we're ready. If that were the case, they could simply delay it in every case. And then once a defendant makes their request for trial, say, okay, well, now we're ready. Don't count any of the time against us. The whole purpose of Barker v. Wingo is that once you've triggered a review and the 4 factors that are laid out fall in favor of a defendant, it's too late then for the state to announce ready and say, okay, well, now let's go ahead and go forward. So we think that argument is not supported by the case law, and it would be counterintuitive to why you would have a speedy trial motion to begin with, or relief under the speedy trial motion to begin with. Moreover, Judge, with regards to that, actually, let me take the next point. Counsel for the state mentioned that, well, it wouldn't be a good idea to be executing warrants during a pandemic. People have gotten arrested every day during the pandemic. There was never a pause on people being arrested on warrants, on new offenses at any time here in Bexar County during the pandemic. So executing arrests and making arrests was not something that was ever put to the wayside, even though there was a pandemic going on. So we think that that argument also does not move the needle in terms of absolving the state of their obligation to bring Mr. Benjamin Gomez to trial. And with regards to the statute of limitations, Judge, either statutorily or through the progeny of cases since Barker v. Wingo, they could have taken out any case that's filed within the statute of limitations and say, look, if it was filed within the statute of limitations, those don't count. You're not allowed to seek speedy trial if they fall within the statute of limitations. But that's not the state of the law. Regardless of them filing within the statute of limitations, that still can be reviewed under the Barker v. Wingo factors for dismissal for a violation of the right to speedy trial.
State, anything further?
Judge, going back to the statute of limitations as we were addressing, I understand what defense counsel is trying to say. However, that applies to cases where the state would sit on a case until, 1 year, 364 days, file it, and then proceed to drag it out for another 2 years. I mean, I would understand a length of delay and a prejudice at that point. But in this case, the offense date was 2019. It was filed at large on 2020, 4/30/2020, and the warrant was executed 9 months later, January 24th, 2021. The length of the delay at this point in the state's eye, while it could trigger the Barker factors, it does not satisfy the rest for the cause of the delay. I mean, at this point, the cause of the delay was that he was a fugitive. There's no other reason for the cause of the delay. I mean, that's it. And the assertion of right, going back to what Mr. Jimenez was saying, I think there were at least 2 or 3 occasions before Mr. Jimenez was counsel and while Mr. Jimenez was counsel that this case was set on the jail court docket, and he was given a right to assert his right to a trial. And every time he kept getting set for a plea, set to hear, to confer and things like that. Not once did the state ever get a whiff of them requesting a jury trial up until this motion was filed. This was their request for a jury trial, was their dismissal for lack of a speedy trial. And the prejudice, like I said, I'm not going to beat a dead horse. We've already gone over that he was not, emotionally distressed, or his defense was not impaired. And pretrial incarceration, we already determined has to do with an ICE hold that was in a place.
Mr. Menace, last chance. I think I got it, but go ahead, and if you got anything else, now's the time.
Just briefly, Judge, through all the state's arguments, aside from saying that it's Mr. Gomez-Diaz's fault that he didn't bring himself to court, there's been no demonstration of cause for the delay. So that, our argument is that completely falls flat and falls in the defendant's favor. Again, we've made a showing of prejudice. And again, the case law says prejudice is not required for a dismissal under the Barker v. Wingo factors once you've reached this point. So for those reasons, Judge, we're going to ask that the court grant our motion.
State, I think I got it, but once again, last chance if you have anything else you'd like to say.
Judge, I think it goes without saying that we are in unprecedented times. So besides the fact that Mr. Benjamin Gomez-Diaz was a fugitive for this amount of time because the case was filed at large 4/30/2020, COVID has played a major role in the justice system and how things are moving forward, which is why the Supreme Court of Texas did stay a lot of statute of limitations. They stayed a lot of dates that have to do with filing and things of that nature on the civil and criminal side. So the state would say part of the cause of delay also it can be attributed to a global pandemic.
Okay. Cause number 638-436, State of Texas versus Benjamin Gomez-Diaz defense motion to dismiss for lack of speedy trial is respectfully denied. Anything further from the state of the defense on Mr. Gomez-Diaz?
Nothing from the defense, Your Honor.
Thank you.
No, Judge.
Thanks a lot, guys. State, if y'all want to go into a chat room or however you want to do this and possibly try to come up with a resolution, you're welcome to do so at this time or any time. But he's got plenty of time in jail, poor guy. So thank you, Mr. Jimenez, and best of luck, Mr. Gomez-Diaz.
Mr. Jimenez,
Mr.
did you want to go in a breakout room real quick?
Okay,
I guess
let's go,
let's go ahead and-
Mr. Jimenez, let's go back
Okay.
into one, and I'll put Mr. Maru in one with you, okay?
Thank you, Pat.
Yes, ma'am. Thank you so much.
And I'm going to let your client go, is that okay? Okay.
That's fine, Judge. I mean, that's fine, Pat.
All righty, that's okay.